son got married in Hawaii, but both of them were California residents, so John did a prenup.
And in this case, with Ed and Georgette, they actually had a very significant family business, that there was some ownership and interest that would be flowing through to their children. And we want to make sure that those assets that were part of that family business and the succession of that family business stay within the family. So it was important not only for James but also for Ed and Georgette to make sure that it protects the integrity of that family business. So we put together a premarital agreement for them, for James, and unfortunately the marriage did not work out. And at the time that the marriage dissolved, they were actually living in Texas. So it was tested by the Texas courts. And as we went through that process, we, as a general rule, are very, very detail-oriented.
It's very detail-oriented, and you didn't want us to leave out anything.
In this case, the premarital agreement was tested in Texas. It absolutely held up.
Attorney for my son and the lawyers and even the judge mentioned what a very wonderful prenup my son had, that it covered so many things that many prenups don't.
Georgette and James were receiving very positive comments from the counsel that they had, from the opposing counsel, even from the judge, detailing how detail-oriented the premarital agreement was.
One of them being that you might have separate property, but an ex-wife is entitled to all of your proceeds, interest, dividends, anything that you get from the moment you're married on that money. And John was very inclusive. James's money and everything that went with it was his.
And some of the areas that can be problematic for that is making sure that you're not only just dealing with the assets themselves and making sure that those are kept segregated, but also assets that might be invested in from those earlier business assets, and also income. That's another area that can often be overlooked. Income from separate property, or even income from wages and earnings. And we wanted to make sure that we had a very, very, very strong firewall around all of the assets that really pertain to that family business, so that if there's income related to that family business or there are dividends related to that family business, all of that is and will be protected. And that's not really even just for James's perspective, because if you have a chink in the armor where somebody else has an ability to get an ownership interest in that family business, they can really wreak havoc on that business. So again, it's more than just the dollars and cents. We want to put together a plan that is going to be fully integrated with the estate plan, so things will actually work.
James just remarried a very wonderful woman, but our son is an anesthesiologist. He has other concerns, especially with the liability that doctors are always under. And so John prepared for him an irrevocable trust before he was married, and then the prenup incorporates that irrevocable trust in that plan.
So in this case, as in many other things, planning opportunities and technologies have changed. And so there are things that we're able to put into the premarital agreement that we do now that you don't often see, that better protect James just in the premarital agreement itself. And we have a slightly different strategy as well. We actually were able to combine that with an asset protection trust, so that way James is protected and his new wife is protected, better protected from claims regarding professional malpractice, those sorts of things, or other creditor claims as well. Then layered on top of that, we actually have the premarital agreement, which references the asset protection agreement, which provides an additional level of protection for James for that and for his children. And once again, we want to put something in place so that it's fully integrated with their estate and asset protection plan.